Here's the second part to the first part of the associated sectional law practices that are obligingly associated with construction projects. There's a couple issues as you're looking at private jobs. There's no written requirement, no contract writing requirement on a private job. The other thing about a private job is that terms and conditions on private work can always typically be negotiated. We're talking about somebody other than the state of Ohio, municipality, county, etc. Public jobs, however, typically you cannot negotiate the terms of a public improvement project that is competitively bid as between the owner, the public owner, and the prime contractor. And there's always a requirement that that contractor be in writing and signed. As a public improvement contractor, when you're working on public work, if you don't have a signed contract with the sponsoring public authority as the prime contractor, you have nothing. If you're out working on public work direct under a contract with a public owner and that owner has yet to sign your contract, you are in a world of hurt. So we always want to say that our improvement contractors that are bidding directly to the public owner do not start work based on a notice to proceed. Do not start work based on notice to intent to award. Start work not when you sign the contract and return to the owner. Start work when the owner gives you the contract that they've signed with a certification of availability of funds. Why have the contract? It serves as a roadmap. Reduces the risk of argument over key terms. What is the schedule? What is the price? What is the terms going to be as it relates to my obligations on warranty? What rights do I have to rely upon? The accuracy and completeness of the owner's plans and specifications. Did I assume that my obligations as it relates to project design? It's going to delineate the rights and responsibilities of the parties it should have guessed. And in your industry, proceeding with anything other than an agreement in writing presents to you more risk. I've had a lot of people say that I'm better off because I didn't have the contract signed. I've never seen or heard of it work to anyone's advantage. Also, I've said earlier that incorporating your proposal into the contract, the reasons we want to see that incorporated is taking the key terms, what are the bases of your fundamental understanding of price, and making sure that either your proposal is incorporated as part of the contract documents and it controls in the event of conflict with any other terms or conditions, or that you make sure that the terms that are in proposal that are material to you make it into the description of work scope. I want to make sure I clarify that on the proposal, your terms, that is the fundamental basis for my price. My work is going to be performed in the months of June and September. And if it moves, equitable adjustments apply. My work is going to consist of this number of men working for no more for a straight time during the week of 4 days a week. And if something has to be done, then there has to be price adjustment. You want to make sure that those things are clear. So you also want to clearly and promptly reject unacceptable terms. Keep the facsimile transmittals. This relates to rejection of change orders. I send you a change order. My change order proposes to pay you $100,000 with no time extension for the added work and schedule delay that you proposed to me would be $1 million and a 6-month extension. Do you sit on the change order in your office? Do you just return it? What do you do? In any instance where you receive something in writing that is unacceptable, incorrect, you need to correct it, and your record should be clear. We're turning unsigned your proposed change order number 1. Your terms and provisions are unacceptable. Our original proposal stands as presented, hugs and kisses. It ought to be in the file. It ought to be sent back contemporaneously. There better be a clear written records. I always hear, what about email? If your contract says that notice in Ohio, if your contract says that shall be sent to Joe Blow by Pony Express, then that's the way it must be sent. If you want to send a copy email as well, great. But whatever the contract says you must do, you must do. I have in here knowing the other party, know your source of funding, Public jobs, it's easy. If you are the prime contractor, it's easy. If you're not the prime contractor, it's holding the contract, then you need to better know who you're contracting with. Am I contracting with the prime contractor who is bonded? Who's their surety? Am I contracting with a sub to the prime? Who are they and what is their payment history like? Are they bonded? Know your source of funding. Like I said, for a prime contractor on public work, it's easy. Anytime a public authority signs a contract, and I'm going to get a contract from the city of Cleveland or Corning, the city cannot contract with them until they actually sign the contract and certify the availability of funds. They must literally earmark the funds and put them in an account to pay their obligations to me, no more. The funds are there, assuming that the owner honors its obligation and releases them from their public fund when they're due. Private owners, I've said it before and I'll say it again, what does a private developer need in order to begin work on a multi-million-dollar project? Well, signatures necessary. Better than that, you need a contractor that's dumb enough to go out there, to go out and start work without knowing the funds are to pay. So I don't have to actually show anyone where my funds are coming from unless they ask. So as you get into these things, when you're looking at the contract upstream, what you need to do is verify, where's my source of funding, Mr. Owner? You want me to sign this contract? We're ready, willing, and able to perform, and I'd like to see that you've got appropriate commitments from the bank, that you've got your funding lined up, you've got your ability to get the TIF bonds or other things that are being contemplated so that a project like this can perform. You will always be at risk. And I say this definitively, you will always be at risk if in fact you sit silent when you get something that you disagree with. The reason is with generally human nature tells us that a delayed response typically is a self-serving response. If you took so much opposition to this at the time you received it, why did you wait 8 months to open your mouth? If you receive this and you disagree so vehemently with the terms, why didn't you return it and reject it? And those classic questions that you get always raise, why wouldn't you say something? Why wouldn't you say something if you disagree? Silence, though, may be deemed acceptance under the law, depending on where you're at, but definitely here in California, voice properly and say so clearly. If you receive your proposed contract form dated blah, be advised that it's unacceptable. It fails to incorporate the proposal dated, whatever it is, or return it unsigned. Also, commencement of performance made to be deemed acceptance. My subcontract to perform, or our general contractor specifically provide, or subcontractor. If you received our form, you begin shifting, or you receive our form, you begin performing. That shall be deemed acceptance, and no material difference in terms in any of your proposals as a subcontractor that is performing work on our jobs shall be deemed accepted unless and until they're specifically authorized by us in writing. So, depending on the terms of the actual agreement, acceptance may be deemed to exist merely by commencing performance, even though you never signed. The other issue in terms of knowing when to walk away, and I can attest to this, in many instances where you've been along for a long time, you have an established bond line, in areas where you can't get an established aggregate bond line, you have a friend who can't find work anymore. They're hurt, they're dead in the water, so you go to your friend, you say, you've got this great relationship with your surety, you've got an aggregate limit that will support my operation. I bid this work to Joe Blow, this owner, it's going to be a great job, but I can't bond it. I want you to step in and sign this contract with the owner and subcontract it all to me, and I will pay you a fee for your bonding capacity to stand in my shoes. And we're going to make a bunch of money. So you come walking over, you're going to get 60 large. So run your bonding capacity. Next thing you know, I default, I don't perform. I can't perform for the price I put together. You just kind of winked at the bid, took that risk. In that particular instance, you thought you were going to make a little cash on the side for your bonding capacity, but at the end of the day, you're the one that is signatory. It's your bonding coming down the hook, and you're sitting there trying to sort everything out. It happens all the time. Contractual limitations, impacts, these type of things that I mentioned in your industry as a contractor, timeliness of notice, perfection of notice, strict compliance with requirements of the contract documents obligate an owner to issue a change order or construction change directive in advance. It is horrible to be a contractor in Ohio or California. If you don't follow the rules what the contract says, you're at great risk of waiving entitlement. There are instances where replete, where contractors done $1 million worth of extra work. The owners and operators were looking in the hole saying, yep, take it out, take it out. Contractor did it. The job was built. The owner turns around and the contractor submits his billing and says, you owe me for an additional 1 million yards of excavation out of the hole of unsuitable materials. The owner turns around and says, no, I don't. My contract says you're supposed to have a change order signed by me before you do it. You didn't get a contract change order signed by me before you did it, and therefore you're out of luck. And the courts routinely say owner wins. Contractor go home. It's a hard $1 million lump to swallow, but that's what the law is. As recently as the last 2 months, 2 decisions have come out from 2 courts, one on one of these school jobs with an Article 8 process where the construction manager was saying, don't worry, we'll work it out in the end. And the contractor said, I'm just going to keep on working and we'll work it out in the end. And it was talked about in the meeting minutes, and everyone said what a great thing this is. And at the end of the day, the owner said, what claim? The contractor said, what? Don't you remember you asked me to do this work? I told you I disagreed. We talked about it. You told me just to get it done, and I got it done. It's all beautiful now. Pay me. And the owner said no. And the court said, owner doesn't have to pay. The Article 8 process wasn't followed. Claims weren't timely submitted. Scope of indemnity, lower tier claims. You will agree to indemnify for lower tier lien claims to the extent that you've been paid for that work by the owner and no more. So if your owner is not paying with accordance to the contract, he wants you to indemnify from all liens and claims made by payment of lower tiers, I would agree to do it. Provided, however, that the amount is being sought by the lower tiers something for what I've already been funded by the owner. There's other things that kick in with indemnity as it relates to what you're agreeing to do for a third party when you're more in traditional roles for an owner coming in, build a suit, design, build, and in terms of what's covered under your policies. You may agree to indemnify from and against loss or damage arising from or related to your work, provided that it's covered, personal injury, property damage, sickness, or death. But the interplay between that type of an agreement of an indemnity, which is okay, is what we need. Personal injury, sickness, injury, or death, or property damage other than the damage to the work itself. And I've got myself or an insured risk. The question is, what is the service you are providing that may trigger the occurrence that gives rise to that claim? People typically blows through these insurance provisions, and if you really looked at what's in the majority of indemnity provisions outside of what's in the traditional standard clause, whether it's the EJCDC documents or the Joint Documents Committee or an AIA form agreement unmodified, in most instances you're in a world of hurt. On indemnity issues, a couple other things. OSHA fines and assessments. Man, when you agree to start indemnitying people for their OSHA fines and assessments, if you are agreeing to do that for the specific fine that would typically be attributable to arcing off those wires, to the extent of you've done it, fine. But if I'm agreeing to indemnify Bruce as the construction manager or the general contractor, and he's have 5 or 6 other instances like this, he's going to get tagged with a huge penalty as a result of his prior history. I would be foolish to assume the risk of agreeing to indemnify him for anything that relates to that incident or occurrence. The point is, if there's a warranty out on the project, and it's going to be a 2-year warranty following data acceptance of the project, do you need final acceptance of the insurance for a period of time to cover the warranty? In most instances, that's going to be an issue that's governed by the project contract documents. Your insurance requirements in your owner-contractor agreement will say what specifically is required to be provided in an insurance certificate as at the time that the project is accepted and closed. And in most instances, they will require a current certificate to demonstrate that you've got the coverage. But in most instances, your contract documents don't necessarily require that happen. It would be prudent for someone to be looking that this insurance exists. But if there's a requirement contractually that somebody named on a policy as an additional insured for a period not to exceed 2 years from the date of substantial completion of the work, if that is your sub that owes it to you, most prudent that you get it from them. There is usually a requirement in most contract documents that follow the completion of the work that the insurance will be maintained for a minimum time period of whether it's 2 years, 5 years, whatever it may be. And some people may say, yes, provided, however, it's commercially available for a reasonable rate. Well, that's the end of that point there. I'm going to move on to another subject.